The Judicial Commissioner also did not enjoy those constitutional safeguards which protect the independence of High Court judge. It was further felt that the extension of jurisdiction of a High Court to the Union Territory would improve the tone of judicial administration in these Union Territories and would inspire greater public confidence. Under those circumstances, jurisdiction of High Court of Judicature at Delhi was extended to the states and Union Territories of the Judicial Commissioner was abolished and a permanent bench of High Court of Judicature at Delhi is established at New Delhi. A judicial officer of the rank of a High Court judge was also functioning in the said tribunal. His duties were multiple, for besides the duties corresponding to those of the Advocate General, he was also the legal advisor of the government of Delhi, as well as he was a sitting member of the Legislative Assembly and of the Government Council. Staff of the registrars of various courts is an important element of justice delivery system which gets ignored most of the times. Proper care is not taken to ensure appointment of properly qualified staff. Their working and living conditions are deplorable. Service careers are not clear. Large number of matters are shouldered by a few staff members. Most of the states have only clerical staff recruitment who rise to become Clerk of Courts, Nazir or Registrar. Between judicial officers and such clerical staff, there is no officer level recruitment of the officials. Minimum number of staff in a given court is fixed by government circulars, unmindful of the number of matters in that court. Most of the times, one benchmark, one assistant bench clerk, one stenographer and two peons are provided to judicial officers of joint courts. Same staff is required to deal with files whether they are 800 or 8000 files. Increase in court files does not result in increase in number of staff. Principal district judge have not been delegated with powers to create post of additional assistant bench clerk even where the overall average pendency has been very high. At many places, identification of ideal number of matters per court have not been done. Policy is required to be made regarding ideal number of files to be handled by a court staff for different courts at different level, and if the number of average matters increase, provision for additional staff be made. An outer limit may have to be fixed for cases where number of files increases double than the ideal number. How the same should be dealt with and what will be the responsibility of the state in such matters. State cannot keep legislating new provisions and laws and crowd cases in courts and then decline to give more infrastructure and staff. Recruitment policy, standard staffing patterns and training policies for staff working in courts need to be settled. There is need of human resource department to be established at the high courts. Post of courts managers are necessary for professional working of registers.